Legal mandates in public schools. Stop for a few minutes and think about what would you say is going to be the biggest challenge to be providing educational supports to students who have disabilities? What do you think is the biggest obstacle that we have right now? Some things to kind of refresh your memory. The Individuals with Disabilities Education Improvement Act, which was amended again in 2004, which is really due for amendments at this point, but obviously we have not seen any. There have been other things that have taken precedence. This is also known as IDEA, even though the letters don't match up anymore since the most recent update to it. So basically what this says, the original law was done in 1975, Public Law 94-142, which was entitled the Education for All Handicapped Children Act. In 1990, the law was changed to be the Individuals with Disabilities Education Act, IDEA, so that the language was in person first language. So all children with disabilities, regardless of the severity of their disabilities and who are in need of special education related services, are identified, located, and evaluated. That's actually the Connecticut statute that matches up with IDEA. So there are 6 major principles of IDEA. I suspect that you are probably familiar with these already, but I will review them really quickly just as a reminder. The first is zero reject, that no student, regardless of their disability, can be rejected from a public school education. Now, that does not necessarily mean that the public school has a program that's appropriate for that child, but that the public school is responsible for paying for that child's educational experience. That a student should get a non-discriminatory evaluation. This evaluation should be done by a team of individuals. It should not be done by just one professional. And also that evaluation needs to be provided to a student who is a non-English language native in their native language. So if the student is not an English language speaker, their evaluation needs to be done in their heritage language. The other expectation is that all students are getting a free and appropriate public education. So what that means is that they get to be provided with whatever it is that is appropriate for them. This is where the IEP comes into play, so that each student has their own individualized education plan. The expectation is that that education occurs in the least restrictive appropriate educational placement. So that we want students to be in the general education classroom is really our ultimate goal. Other things that you might see are the general education classroom with resource room supports, or a segregated special education classroom in a school. But really our ultimate goal is that all students have some time in the general education setting. The other expectation is that there are procedural safeguards. This is where the due process piece comes into play to prevent school systems from doing things that are not the right thing to do for a particular student. Due process can also go in the other direction, but it is typically not initiated by the school district. Usually parents are the ones who are initiating due process. The 2004 amendments have an expectation that before you file a lawsuit, that you will go to mediation first as a potential way to prevent the situation from needing to go into the court system. Generally, when things end up in the court system, they don't get solved in any timely fashion, and more often than not, the student who needed for something to change is with or without whatever it was that they needed for a fairly extended period of time. So you really want to try to avoid going into a court situation. And the last major principle of IDEA is that there's an expectation of parent participation and shared decision making, that parents or family members or a legally appointed guardian are a team member with equal voice in a student's educational experience. So here's a nice chart that came from the Connecticut State Department of Education to look at the identification process. So if a student is referred for a special education evaluation, the first thing that needs to happen is that a planning and placement team meeting must be held to take a look at that referral. That referral could come from a teacher. That referral could come from going through the SRBI process and getting to Tier 3 and finding that the student really is not making appropriate gains in their educational pursuits. It could come from a parent or legal guardian putting in writing that they want the child evaluated. So the PPT would look at the available data. They may make several. They have the potential to make one of 3 recommendations. That there is not enough data to support a comprehensive evaluation, that there's really no suspected disability. That happens on occasion. Sometimes parents think that the child is not progressing adequately and believe that it might be a need for a special education program, and it turns out that really that's not the case. A comprehensive evaluation is needed, and there's not really enough existing data to determine eligibility. So a whole evaluation process needs to be put into place so there's enough data. This cannot go through if the parents have not consented to the student being evaluated. So if a teacher has made a referral and the team believes that the student should be evaluated and the parent does not consent to an evaluation, then the child will not be evaluated for special education services. Then we might review the existing data and feel that we have enough data to move forward. So then the PPT comes back together, looks at the data that they have. They may determine that the student does, in fact, meet the eligibility requirements for special education services, and they develop an IEP. They may find that the student actually has a disability but really does not fit the criteria for getting special education services, but is eligible for a Section 504 plan, so that's put into place. Maybe that after the evaluation is done, it's determined that the student really does not have a disability. That could be an option and nothing happens. Or it could be determined that there's not enough data and we have to go back out and get more data. In some situations, sometimes the person who needs to be doing certain types of evaluations is not somebody that is available in the school. So you may find that sometimes you don't have data that you actually need. So again, once you get more data, we could be in the same situation, determining not a disability eligible for special education supports, a disability not eligible for special ed supports but gets a 504 plan. So if you do have a student who actually has a disability and is engaging in really significant problematic behaviors, has some really significant challenging behaviors, one of the things that needs to be evaluated is this behavior related to that child's disability? So let's say you have a student with a disability who pulls another child's hair, and the typical action at your school is that a student would get suspended for something like that. But you have to look at what is going on with this child with this disability. Is the reason that that child pulled somebody's hair a manifestation of their disability? So the team needs to take a look at that. If they think that it could be related to the disability, they need to conduct a functional behavioral assessment and implement a behavior intervention plan or revise an existing plan. If the student, the behavior is not related to the disability, is it related to a failure to implement the IEP? If it's not, then the student would be disciplined according to whatever the school's policy is. If it is related to the person's IEP not being implemented correctly, then steps need to be taken to make sure that the IEP is implemented correctly. If this team has done the FBA and the behavior support plan, the student might remain in their original placement, or the team may decide that the student's placement is not appropriate and makes recommendations to change the placement. If you had a student who had some very, very severe behavioral issues, you may find that this is a situation that the student needs to be outplaced for some period of time. So those are some things that we need to keep in mind as we are looking at, does the student have a disability that is part of the reason why they have engaged in a particular problem behavior. So let's say you had a student who had a learning disability who decides to start selling drugs at your high school. That's not a function of their learning disability. So that child would be disciplined according to your school discipline plan. Now, if you had a child who perhaps had an intellectual disability and another student persuaded them to put something in their locker that they didn't really know what they were putting in their locker, and it turned out to be, say, drugs, the error in judgment is probably a manifestation of their disability, so you would probably make a different decision about how that student would be treated. So just some reminders about who should be on the student's team, who needs to be at a PPT. You need a core team, you need a special education teacher, a gen ed teacher, parent or guardian, or an administrator to have an official PPT meeting. So those 4 people need to be present. The parent or guardian could be present by phone, or I suspect in this current day and age, potentially a video conference, but the other folks need to be in the room, and they need to stay in the room. An administrator who comes in and says hello and leaves is not an administrator who is at a PPT meeting. Some other people that might be at a PPT could be an occupational therapist, physical therapist, speech and language pathologist, the nurse, school psychologist, or a school social worker. In schools where those folks are not necessarily full-time employees, you may find that you don't want to invite them to meetings because you have to pay a consulting fee for every time they come to a meeting. It may not be the best use of time. But what needs to happen is they need to send their reports in advance so the team has an opportunity to take a look at them, and they need to be available by phone during the period of time that the meeting is occurring in case there are any questions. I personally think that when students have paraprofessionals, those individuals should be included in PPT meetings. They are oftentimes the person who knows a great deal about what's going on with that student. They may or may not necessarily be using all of the educational jargon, but they most certainly know much more about what's going on with that student oftentimes than anyone else. If you can't get the paraprofessional into the PPT meeting because of scheduling challenges, I would encourage the teachers to make sure that they talk to that individual before they go into meetings and they bring in the information that that person has. The other person who I think should be at a PPT meeting is a student, most especially when students are in high school, but also kind of working up to that as students start getting maybe towards the end of the elementary school years, that maybe they come in for about 5 minutes at the end, or that the student is asked in advance some questions about things that they might want to work on, and that information is brought to the PPT meeting on the student's behalf. You certainly don't want a student who is at the point of becoming an adult and turning 18 to not understand what these meetings are all about, and then find that that student has complete and total control of their educational experience and has now decided to, I don't know, change situations, not take some of the supports that they're being offered, leave school maybe before they really should. We want to make sure that they're part of this team on a regular basis so they understand what's being done on their behalf. There's a link here that goes to the Connecticut IEP. I would encourage you to take a look at it. I would actually encourage you to perhaps download it until the new IEP form comes out. This link sometimes disappears, but it explains all of the different pages of the IEP. It's meant for families, but it's a very informative document, especially when you have a new professional in your building, a new teacher in your building who is not as familiar with the IEP form. It explains what each of the different sections are, why the information is there, and what it all means. So I think it's a very helpful link, so you probably want to take a look at that. Another thing to keep in mind is that there is an expectation that when we have situations where students are having a lot of behavior problems, that we actually need to start considering that as a potential indicator that that student may actually be having other challenges, and that we may need to be evaluating them for special education services, especially when you have students who are consistently suspended or have behavior or attendance problems, who don't necessarily carry a diagnosis of a disability, that we need to go in and we need to actually take a look at that, because the reason for some of those behaviors could potentially be a disability that has not been identified. The other thing that we need to take a look at is what happens when we have students who are habitually truant. If they have not been evaluated during the preceding year, there is an expectation that the juvenile court will order the local education authority or the regional education authority to perform an educational evaluation. Because is that student truant because they are having difficulty academically in school and they're trying to spend as little time there as possible? So we need to make sure that the reason for their truancy is not that they have a disability that has not been evaluated. Another thing to keep in mind is that school districts can certainly report students who have disabilities for committing crimes, and they certainly should be doing that. It does not necessarily, IDEA requires that the school district would share information with the court system, but you need to make sure that all the appropriate paperwork has been done, that the family or the guardian has signed things so that you can actually share that information, because that information may be very helpful as a student finds themselves in court. If it's a student with a disability, there may be some underlying impact of their disability that led to their engaging in this particular violation of the law, which might be taken into consideration as somebody is making a determination about what their punishment might be. The other thing to keep in mind is that when students actually get into the juvenile justice system, their behavior plans or behavior intervention plans are often disregarded. And many students within the context of the juvenile justice system are actually students who have labeled or unlabeled disabilities. So it becomes, unfortunately, an incredible injustice that they end up in the judicial system without people necessarily having the information to know what other services and what other needs that student might have been displaying. So when you have students within the context of your school who have a labeled disability, who are also engaging in challenging behaviors, whether it be aggression or shouting out in class or running away, the expectation from IDEA is that a functional behavioral assessment will be done. This is typically done in most school districts by a board certified behavior analyst or the school social worker, the school psychologist, the special education teacher might be conducting this behavioral assessment. In some situations, you may find that they bring someone in from the outside to do that, depending upon the resources in your district. Once that functional behavioral assessment has been conducted and there is information about the communicative intent of that individual's behavior, a behavior intervention plan is written to help that child change their behavior, to find other ways to communicate their wants and needs as opposed to whatever the challenging behavior is that they happen to be exhibiting. So there is a legal expectation that when students with disabilities are having issues with challenging behaviors, that we're conducting an FBA and that they end up with a BIP. The Rehabilitation Act of 1973, Section 504 is really the key piece that impacts us within the context of the public schools. There's a link here to a video that gives you some historical perspective on Section 504. If you're interested in the history of it, I would encourage you to take a look at this. There has also been, I believe it's a Netflix movie called Crip Camp, CRIP Camp. Not necessarily words that I would use, but it was actually done by folks with disabilities who attended this camp in the Catskills, and many of the folks that attended that camp are also the same people that you will see protesting and advocating for the Rehabilitation Act of 1973 to get passed. So it's sort of an interesting connection between those two things. So Section 504 of the Rehab Act basically says that no qualified handicapped person, probably not the best language, but it's from 1973, on the basis of handicap will be excluded from participation in, be denied the benefits of, or otherwise be subjected to discrimination under any program or activity which receives or benefits from federal financial assistance. So public schools fit that completely. So in 2008, when the Americans with Disabilities Act was amended, there were some things that were looked at: mitigating measures, clarifying major life activities, and an interpretation of substantially limits. So the student's disability needs to really get in the way of major life activities and substantially limit their ability to participate in the school. One of the things that is a kind of a problem with Section 504 is that when we look at data, really only 1 to 2% of a school district's population should really truly qualify for a Section 504 plan. But in reality, in many districts, between 20 and 30% of the students are getting services under a 504 plan. There's a reason for that over-identification. Sometimes it's parent request, depending on the school system. Things will just get put into place because parents are asking. Some families believe that if they come in with a physician's recommendation that their child is going to get accommodations with a 504 plan, that those will automatically be put in place, which is not necessarily the case. Even though there is a physician's note that indicates a need, the school district still has a responsibility and an expectation to truly evaluate whether that need is legit within the context of the school. And they have to really look at, is this really impacting a student's opportunities educationally? So there are some students who have disabilities that do not actually need services. It's not impacting their academic performance. So we need to be looking at all of those things. We're going to do a little group activity when we get back together for class. And just a couple other legal actions that have been taken that have an impact on us as we are providing services to students within the context of the public schools. PJ et al. Versus the State of Connecticut Board of Ed was a case that was done in 1991. Some of you may be familiar with this. It was initially a case that was put into the court system by PJ's family. He was at the time, I believe, a kindergartner with Down syndrome whose parents wanted him included in the general education environment, and initially the school system said no. So they ended up filing a due process, and it started with other people getting involved and wanting the same thing. So it became a class action suit. Actually, PJ ended up being included and didn't really need this class action suit, but it had an impact on other students with intellectual disabilities. So it was certified as a class action suit on December 13th, 1993. It was settled out of court on May 22nd, 2002. And basically the class membership for this is really truly all school-age children with the label of, at the time was mental retardation, which is now intellectual disability, on or after February 20th, 1991, who are not educated in regular classrooms. So that was the group that it was really focusing on. However, many school systems in the state of Connecticut took the outcomes of PJ and really tried to implement them for all students with disabilities, even though the settlement was really only meant for students with intellectual disabilities. I think this is actually good practices that they're trying to do this for everyone. So the expectation is that we want students to spend 80% of their school day in general ed. This is where you may hear folks talk about an 80-20 split, that you spend 80% of the school day in gen ed and 20% getting other types of services. It could be physical therapy, it could be working with a school counselor, it could be going to the resource room to work with a special ed teacher, but that you've got 80% of your day with other non-disabled students. The expectation is we try to reduce over-identification of students from minority groups as being individuals with intellectual disabilities. For those students who are not hitting that 80-20 split, that we try to increase the percentage of their school day spent with non-disabled peers. That we want students to be in their home school or their neighborhood school, that we don't want students going across town to a school that's not in their neighborhood. Because generally when you're trying to make friends and build relationships, especially with younger children, they typically build them in their neighborhood. So you want to try to avoid having a student go all the way across town for school, which stops that cluster of this is the school that has all the students with intellectual disabilities. The other expectation is that students with intellectual disabilities are given opportunities to engage in extracurricular activities along with their general education peers. So that's the PJ case, which was here in Connecticut. Another case that's had an impact on us recently, I'm not sure that we've seen a lot of impact in Connecticut at this point, but it has really set a standard. It really clarified the free appropriate public education standard for the first time in 35 years. This was a case that was brought against the Douglas County School District in Colorado by Andrew F. and his family. He was a student with autism. Parents were not satisfied with the education that he was getting in the district. They felt that they were holding him back, that they really were not providing him with an opportunity to really progress. So the parents pulled him out and put him into a private school for students with autism without the district saying that they would pay for it. So they end up taking the district to court with the expectation that the school district would pay for his private school placement. This went to the Supreme Court. This is the first time in 35 years that a special education case on FAPE was argued in front of the Supreme Court. Most of the rest of them have been settled in the lower courts. So the expectation is to meet its substantive obligation under the IDEA, a school must offer an IEP reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. So the real expectation is that a student will make more than minimal progress. So we don't want to be setting our goals in IEPs too low so that we're really not pushing that student to sort of live up to their best expectations. Obviously, you don't want to set goals so high that the student can't get to them, but sometimes people actually set goals lower than what a student could really achieve because they want to prove that the student hit their goals, when we really should be trying to set the stage so the student makes the most progress possible. So that's Andrew versus Douglas County, which was the most recent legal action that we've seen in the area of special education. So just some thoughts about folks with disabilities. There's a link to a YouTube video here. A woman named Stella Young, who is an individual with disabilities, kind of talks about the way that folks view individuals with disabilities. She's relatively humorous, but I think she brings out a number of points that are things that we really should keep in mind. So I would encourage you to take a look at that video.